So in today's video, I want to talk about municipalities and municipal immunity, and this is something unique to Wisconsin. So Wisconsin has a set of rules. They're found in Chapter 893 of the Wisconsin statutes that you need to be aware of if you're involved in a crash or an accident, or maybe even a slip and fall, something like that that involves a potential party that is a municipality or government agency. For example, the state, counties, cities, villages, the DNR, places like that. Anything that is or may be municipally owned and operated, you need to be aware because they have special rules, special notice rules that need to be followed, or it can jeopardize someone's case. So, what are they? So, the basic rule is this: within 120 days of a car crash or auto crash or something that involves a potential municipal party, just potential. Maybe you pursue something, maybe you don't. But if you want to have a chance to pursue something later on, you need to serve a written notice of circumstances within 120 days of whatever event caused it or gave rise to it. The car accident, whatever, the slip and fall injury. It's 120 days from the date of that to provide written notice to them. And the statute lays out who to serve. If you serve this, if it's the state of Wisconsin, this is who you serve. If it's a municipality such as a county or city, this is who you serve. And the statute lays out what kind of information needs to be in there. This is where it's really, really important to talk to an attorney as soon as possible so that they can do this for you and make sure that the notice requirement is being complied with. The rule is especially strict when it comes to the state of Wisconsin, a little less strict when it comes to counties and villages or whatever, but it's always the best to try to comply with that 120-day rule if at all possible. Otherwise, it can later jeopardize a claim. Once a notice of circumstances has been done, then you have some time, your attorneys have some time, but eventually a formal claim has to be submitted in writing on either the state, the county, the municipality, whatever the case may be. You actually have to make a written demand on them for a certain dollar amount or a certain relief, and then that they have time to respond to that either by ignoring it or formally denying it. And then the statute provides another deadline that a lawsuit has to be brought within 6 months of that denial. So this sometimes means that we don't make a notice of claim right away because we don't necessarily want or are going to be ready to file the lawsuit within that 6 month period. So sometimes you can serve the claim with the notice of circumstances, or other times your lawyer just wants to serve the notice of circumstances so they're on notice, and then later submit a claim prior to filing a lawsuit. So it's really, really important if you have a potential government municipal agent that's going to be sued, firefighters, things like that, that you make sure you talk to a lawyer right away so they have time to take care of these rules and preserve your rights.